Please be seated. We have 4 cases on the docket this morning. We're going to take them in the order that they appear. After the first case, we're going to take a break for coffee. We invite everyone to join us for coffee in the Commons after the first case. Are both sides ready on the first case? Helen may proceed.
Good morning, Your Honors. I'm Barbara Basharis, representing Sherry Overstreet. I'd like to reserve 3 minutes for rebuttal, please.
Okay, I will try to remind you, but you're going to be responsible
I'll watch
for this
the light. Thank you, Your Honor. Your Honor, Ms. Overstreet is here today asking you to reverse her conviction on a very narrow issue, and that is the issue of the issuance of a warrant for her medical records at Flowers Hospital after the accident in which she was injured and her 2 sons were killed. The warrant was issued, it's undisputed, in Alabama, and was upheld at the trial court under the standards that are applied in Alabama for search warrants. Alabama's law is not as particular as Florida's with regard to warrants. The information or the factual information supporting a determination of probable cause does not have to appear on the face of the warrant, but can be supplemented with oral testimony to the issuing officer. The trial court here found that the Alabama officer who obtained the warrant had complied with the law and thus that the warrant would be upheld. But it's Ms. Overstreet's contention that the warrant did not satisfy the standards of Alabama law, and therefore it was error to allow that evidence. It's undisputed, I think, in the record that the trial court here said that the warrant would not have complied with Florida law because the search warrant was issued based on a bare-bones affidavit that simply said that Ms. Overstreet had failed to control her vehicle and that there had been a crash resulting in 2 deaths. There were no factual allegations in the affidavit showing probable cause that an actual crime had been committed. Alabama, as I said, allows oral testimony to supplement bare-bones affidavits, but the oral testimony itself has to be specific in support of a finding of probable cause. It's not enough for the officer or officers who obtain the warrant to simply come into court later and say, I told the magistrate everything he needed to know, or I told the judge everything she needed to know to issue the warrant. There has to be something for a higher court to review when you're looking at a probable cause determination. And an illustration of that is the case we cited in the initial brief, the case of Swain, where the affidavit itself was insufficient, and the officer who obtained it testified that he went to the judge when he obtained it and reviewed his investigation with the judge, but did not provide any specific information from his investigation.
Didn't the trial court here find, and I'm talking about the Florida trial
yes,
court.
Florida court.
Didn't the Florida trial court find that the Alabama officer, when he went to get to the search warrant, did in fact have the probable cause affidavit from the Florida trooper?
The Alabama officer had a probable cause affidavit from the Florida trooper. But, Your Honor, we would argue that that falls under the heading of subjective information that the Alabama officer had. Under Alabama law, it doesn't matter how much the officer knows when he or she goes to seek the warrant. What matters is the information that's specifically relayed to the judge who says...
Didn't he say he gave the judge that probable cause affidavit? I know it's not clear the judge read it, but we never know how much a judge reads.
It's not clear that the judge even looked at it, Your Honor, and there was no specific testimony that facts from that probable cause affidavit were relayed to the judge over and above what was on the face of the affidavit, which itself was deficient. I believe it's the answer brief, the state's answer brief alludes to the probable cause narrative actually being attached to the affidavit, and I think that is an error. There's nothing in the record indicating that the probable cause narrative was actually attached to the affidavit that was handed to the judge to sign. The officer who obtained the warrant simply said, I put all the paperwork I had together and took it to see the judge. We don't know what the Alabama judge actually looked at or actually knew when he signed off on that warrant.
But we have to go by what the judge was provided, correct?
If we know that he was actually provided it, Your Honor, and that's...
If I may, I think there was a finding of fact he was provided the affidavit, the probable cause affidavit by Trooper Gordon or Golden.
Trooper Gordon was the Florida trooper who filled it out, and I believe it was Officer Brazier, who was the Alabama officer, who went in search of the warrant.
But there was a finding of fact that the Alabama trial judge had the affidavit by Trooper Gordon, correct?
There was no finding of fact that he saw it. There was a finding that the officer took it to him. I believe that.
So there's a finding of fact that the Alabama trial judge was provided a copy of Trooper Gordon's affidavit, correct?
Your Honor, I am not sure that that's exactly what the finding of fact is. I remember the trial court saying that Alabama law was complied with. I don't remember the record saying specifically that the affidavit was placed in front of the issuing judge. I'm sorry.
Well, I understand, and the reason I'm asking this is I think it's a good starting point to clarify that the trial court had the probable cause affidavit that Judge Wolf alluded to. Now, you made a comment in response to the judge's question that, well, under Alabama law, subjective information cannot be utilized. Could you address that in more detail?
Yes, Your Honor. The Alabama cases addressing this situation generally illustrate that the subjective knowledge of the person seeking the warrant isn't enough to justify the issuance of the warrant. In other words, the officer can't come into court at the suppression hearing later and say, well, I knew that this happened. I knew that drugs were in the house. I knew that she had been seen drinking. Whatever that officer's information is, the officer has to be able to come in and say, I told the judge this, this, and this at the time the warrant is issued. That's what I meant when
I was looking for this earlier. I'm sorry for interrupting, but on page 56 of the transcript, which I guess is 306 of the record, it said, this is the Florida trial judge talking. Now, the packet of information that Mr. Brazier said that he gave to Judge Holloway does include Trooper Gordon's complaint form. And I reviewed that, and I do think that there are facts in that complaint that would establish probable cause to believe the crime of DUI manslaughter had occurred. Alabama law in allowing an affidavit presented to the judge to be supplemented by additional testimony. That testimony having been presented to him, isn't there an implication of what I just read, that, in fact, Trooper Gordon's probable cause affidavit was, in fact, presented to the Alabama judge? And I'm asking that because I have a problem when something's presented to a judge to try to second-guess whether it was actually read or not. We never know exactly what's read.
I understand, Your Honor. I think that's why it's important that there was no attachment of the affidavit to any documents, and there was no incorporation of any other documents by reference in the affidavit. And that's
why Florida law is probably better than Alabama law, because we require it to be attached.
Because Florida law allows for that decision to be reviewed later, because then you have an actual affidavit to look at that contains the facts that the court had to base its decision on. Here we don't have something reviewable. In the Texas case that the state had cited, the case of Kotler, which was an analogous situation involving the supplementation of an insufficient affidavit, the affidavit was actually attached to a probable cause narrative and referred to that other document. So that in that case, the reviewing court said maybe the four corners of the affidavit are insufficient, but it clearly incorporates this other document by reference. Here we have a situation where there's no clear incorporation of anything else by reference. And you're right, Your Honor, there's an inference you would have to make to find this sufficient, that the judge actually read that, or that information was orally relayed to him before he signed the warrant. And we think that is too much of an inference to support a finding of probable cause.
It's not really the only inference. If the judge, the Florida judge, relied on that affidavit, which he clearly did, and he said it was given to the judge, aren't we kind of stuck with the factual findings from the Florida judge?
The problem is we know that the Florida judge saw the affidavit. It was in the Florida court. We don't know that the Alabama judge saw it or was told information from the affidavit. We have the testimony of Officer Brazier that's very general, saying, I basically told him the facts that were in the narrative, that there had been an accident. But we don't have him testifying, I told him that the driver had been seen drinking, or that the driver had been observed exhibiting signs of intoxication before she got behind the wheel of a car, and therefore there's probable cause to believe that she was driving while intoxicated. And that also distinguishes the situation from some of the Alabama cases that have allowed warrants to be supplemented for being deficient in terms of time or place where something happened. I know there's several cases. I think Parker is one of them. Oliver is another, where a warrant was issued to search premises for drugs, and the warrant itself was not specific as to when the drugs had been seen at the premises, or how much or what type of drugs had been seen, but that specific testimony was presented at a suppression hearing in the form of an officer saying, I told the judge that our confidential informant saw it last night, or I told the judge that the confidential informant reported seeing marijuana at the residence. And so that level of specificity is what allows a reviewing court to say, there was probable cause here. And that's what we don't have. We have a general statement that I told him what was in the narrative, which is like the statement from Swain, I went over my investigation with the judge. And in Swain, that was insufficient, even though clearly looking at it from the vantage point of hindsight, there had been investigation, there were facts known to that officer about what the defendant had allegedly done. Still, it was insufficient for him to go and say, I reviewed my investigation and the judge issued the warrant. Under Alabama law, you need more specificity than that.
Got about 3.5 minutes.
Okay, I'll reserve the rest of my time. Thank you, Your Honors.
May it please the Court. My name is Bowen Robinson, and I represent the state of Florida. I filed a notice of appearance last week. I'd like to get basically to the central issue here, which is what establishes probable cause in the state of Alabama for a search warrant. And as the Court has already stated, basically you can go beyond the four corners of a, quote, bare bones affidavit to include all the information that's before the issuing magistrate. If I could quickly direct the Court to a case, Credenton v. State, which is cited in the State's answer brief, which states that we view the evidence from the position of the magistrate who issues the warrant and attempt to determine what information was in that official's possession at the time of the issuance of the warrant. So what was in the official's possession at the time that he established probable cause? We have the affidavit from the Alabama officer, Officer Brazier, which the appellant would be quick to point out is a bare bones affidavit, which probably does not establish probable cause. But we also have, as the Court has already pointed to, this Florida probable cause narrative, which was prepared by the Florida officer, Officer Gordon, who investigated the crash and clearly was included in the paperwork. And the Court had already gone over this matter, but in Volume 2, page 272, 273, 274, it's hammered home at the suppression hearing that this information was included in the paperwork. Again, I go back to Credenton that it was in the official's possession at the time that probable cause was decided.
Okay, but you'd agree that we don't know whether the judge actually viewed that probable cause affidavit, do we?
Yes, Your Honor.
From the record here, we can't tell.
Yes, Your Honor. And what I would say there is what the Court's getting to and what the appellant had alluded to is sort of a policy argument. I mean, are we going to make an officer at a subsequent suppression hearing have to testify that a judge actually read a document? Who's to say, how can he testify to that? The judge looked at the document. We looked at it. Did he read it? Was he just looking at it? What was he looking at? We have here the Alabama affidavit. We have an Alabama incident report.
Let's assume that the judge did not read the affidavit. I know you don't want to make that assumption, but let's assume that for a second. Would the testimony of the officer that I recounted to him what was in the affidavit, would that be sufficient when the officer said, well, I really can't remember exactly what I told him, but I recounted what was in the affidavit?
Yes, sir. I would say there that in all the cases, again, that are cited by the appellant, both Lewis and Swain, The testimony at the subsequent suppression hearings was they could not testify as to exactly what facts were before the issuing magistrate. Here, I don't want to get away from the fact that that was actually included, but there's also testimony specifically at page 287 of Volume 2, which says that he testified as to a brief summary of what was included in this affidavit, which included in this affidavit was a statement of 5 witnesses who stated the appellant was impaired, staggering, slumbering, slurring her speech, includes statements from a gentleman, the bar patron, who dropped her off at her car before she decided to get in it and drive away from the Crofts residence, that she both vomited.
So I don't think there's any dispute that that trooper's statement provides probable cause. I assume the appellant would likely agree. But the appellant's argument is that it was not attached to the affidavit. Can you give us more clearly exactly how the trial court found that the Alabama judge had Trooper Gordon's narrative in his possession?
How he knew that he had it in his possession?
Yeah, what is the trial court's factual finding or his implication that the Alabama magistrate had Trooper Gordon's narrative in his possession when he issued the search warrant?
Well, Officer Brazier testified at the suppression hearing that that information was included in the paperwork given to the Alabama judge at the time that the probable cause determination was made. And I would also state that, under the standard of review in this case, I think a reasonable inference can be drawn from these facts that the judge actually read what was before him. We're talking about 3 documents here. It wasn't a book. I think that it's reasonable to infer that he read the details of that probable cause affidavit in coming up with the probable cause determination, the Florida probable cause. And in addition, even if somehow the court were to find that the search warrant was invalid, it can still be admissible under the good faith exception, that this officer acted in good faith and objectively reasonable reliance on the warrant. There's no evidence of bad faith on the part of the officer or flawed execution of the search warrant. The only possible exception to good faith that the appellant could possibly make is that the warrant was so lacking in indicia of probable cause as to its reliance would be unreasonable. If I could point the court quickly to language from Leon, which states that the good faith reliance is clearly an objective test and is based solely on the facts presented to the magistrate. In the supplemental Alabama case, the state supplemented Nelms, the court held that Leon was not met in that situation. But again, in that situation, similar to the cases cited by appellant Lewis and Swain, the affiant officer at the subsequent suppression hearing could not recall specifically what he had told the issuing judge. But what this case is important is that it shows Alabama's willingness to supplement an affidavit in a Leon good faith situation. So if the court, again, the Alabama state law, if you go beyond the 4 corners of the affidavit, you can clearly find that this affidavit is not so lacking in indicia of probable cause that reliance would be unreasonable. So in closing, the state would just like to say that the information that the issuing judge established probable cause that criminal activity had occurred. The trial court's ruling...
Let me just, one other issue that was kind of argued in the brief, if you haven't dealt with an oral argument. You would agree that the test for harmless error is the Florida harmless error test?
Yes, sir, I would agree.
Do you think if this court finds this warrant to be issued in error, that the harmless error test is met under DeGuilio?
I would argue that an argument could be made that there's no reasonable probability that the error contributed to the verdict, in that we have statements from a number of individuals that the appellant was in fact intoxicated that were made at the Florida trial. But again, I would go back to on the merits that probable cause was established. In the case that it wasn't, clearly good faith would apply. And so the state would ask that this court affirm the appellant's judgment and sentence entered in this case. Thank you.
Thank you. Rebuttal?
Your Honors, the Alabama cases involving the good faith exception make clear that a good faith exception is not available for a bare bones warrant. We're not contesting that the good faith exception is theoretically available in a situation where a warrant is supplemented with oral testimony. But the case of Moss, the cases of Parker and Lewis all stand for the proposition that the good faith exception is not automatically granted to a defective affidavit, regardless of...
Would you concede that the Florida officers acted in good faith? I mean, they couldn't go... I guess they could have gone up to Alabama and been with the...
I'm not arguing that the Florida officers acted in bad faith. No, Your Honor. But I think when you have a situation like this, we have to look at whether the actions of the officer seeking the warrant and the judge issuing the warrant are reviewable by a Florida court, if that evidence is going to come into a Florida court. And that's where the good faith exception doesn't help us, because when the affidavit itself is so bare bones that reliance on it by itself would be unreasonable, the court has nothing to review. At that point, we have to go back to the Alabama requirement that the supplementing testimony or the supplementing information be specific enough to support a finding of probable cause. And that has to be a finding of probable cause that you can see.
Well, you're not disputing that this supplemental probable cause affidavit by the Florida trooper is specific. You're just saying you're not sure whether the Alabama judge actually read it, right?
That's correct, Your Honor. We are not disputing that. If you look at the...
What if instead of probable cause affidavit, what if the Alabama trooper had told him these facts in oral statements as the Alabama cases? How would we know that the trial judge listened? How do we know he wouldn't be turned around on his laptop doing something else?
Your Honor, I think at that point there was a question earlier about what inferences we can draw about what the court does and doesn't do. I think it is a proper inference that if you have sworn testimony from a law enforcement officer, I told Judge Smith the informant was there at 7 o'clock, that the judge hears that. What's not sufficient is if the officer says, well, I knew when I went to see Judge Smith that the informant had been there at 7 o'clock, but I'm not sure whether I told him that specifically or not. So, yes, if a statement was made specifically to the judge, I would not argue that you should infer that the judge didn't hear or the judge was doing a puzzle at the time or that the judge was otherwise distracted. But you have to be able to look at what was conveyed to the judge, and that's where the chain of information breaks down in this case, because we don't know what was actually conveyed to the judge. We know what the paperwork that was taken to his chambers was, but we have no specific testimony about the information that was given to him from that paperwork. I would say, Your Honor, if Deputy Brazier had testified specifically, I told the judge that I had a narrative which said she had been seen drinking, that she had been observed by 5 witnesses. At that point, I wouldn't be standing before you making this argument, because then there would be specific facts in front of the Alabama judge supporting a finding of probable cause. But we simply don't have that based on the record that is before you today. I would also just say about the harmless error test that I think, given the volume of testimony relating to the blood work in this test, that the state can't meet the burden of proving that that didn't contribute to the verdict in this case.
Your time's run.
Thank you, Your Honors.
Okay. We will stand in recess for about 15 minutes, and we invite everybody to join us in the Attorney's Commons for some coffee.